Hello everybody, Ed Cross, TRL here. One of my contributions to the IICRC standards is a statement that it's impossible to formulate a standard that could apply to every situation, and that in extenuating circumstances, deviation of the standard of care may be appropriate. That might serve as an escape hatch. The contractors are judged by what's reasonable under the circumstances, and these are certainly trying circumstances. One might use the IICRC escape hatch to argue that reasonable care in this situation for a contractor is different during a widespread catastrophe that causes serious material and labor shortages in a crisis situation, and that some mitigation may be better than no mitigation at all. But I would not hang my Stetson on that. So, can a release save you? Well, the decision to request a release can be a difficult judgment call. If you've had the joy of being involved in litigation, you've probably seen a release, and you probably figure you could take it to the bank. But there's a difference. You see, there's no logic in prohibiting people from settling existing claims. That's not the question here. Issues sometimes arise when someone asks for a release before any damage has been done. These kinds of releases are generally disfavored by courts, so contractors should not be making widespread use of them, because courts sometimes will reject them. Every workmanship case I've ever seen in this arena includes a claim against the contractor for the tort of negligence. Releases pose a conflict between tort law and contract law. And here's how I see the arguments going here. On one hand, public policy supports the system that allows suits against contractors for the tort of negligence to reinforce a reasonable standard of care that requires wrongdoers to provide appropriate recompense to injured parties. On the other hand, the law holds in great reverence the freedom of individuals to limit their future liability by contract. Contract rights can be waived, but courts across the country look skeptically at those who attempt to contract away their legal liability for the commission of torts. For example, some courts have held that pre-injury releases for gross negligence are against public policy. So if you feel you need a release, what are the types of situations where they're upheld? Releases are subject to the state's fair notice requirements. Unless you can convincingly prove that your customer had actual knowledge of your disclaimer, which they would probably deny, in order to establish a waiver of rights under a contract, you almost certainly need written proof of an intent to relinquish a known right. These waivers must be express, conspicuous, and specific. Express means that the written waiver must actually state that the person signing the release releases the other party from claims for negligence. And ideally, it would explain the types of claims, like personal injury, mental anguish, and loss of property value. The conspicuous requirement provides that the waiver must not be hidden in the fine print of a contract. Instead, it should be clear, based on the title, size of font, use of bold lettering, etc., that the person signing the document is signing a liability waiver. Courts may consider many different circumstances of the transaction in deciding whether to enforce a release. But here's my rule of thumb for drafting a release. If it would not capture the attention of a reasonable person looking at it, it may not be enforceable. Courts have declined to enforce waivers that exempt landlords from liability to their tenants, for example. Why? Due to the unequal bargaining power of the parties and the take it or leave it nature of the contract. We don't want take it or leave it restoration contracts, and restorers need to be prepared for that same type of argument when they seek to enforce a waiver that's signed during a crisis. There will always be news reports about fringe opportunists trying to take advantage of a catastrophe. And this may change public opinion and create a challenge for legitimate contractors going to court. Plaintiffs' attorneys are salivating at the opportunity to paint a picture of a charlatan contractor who strong-armed a distraught owner of a damaged home into waiving a bunch of different rights. So keep your releases tight, keep them fair and conspicuous. Using them as a substitute for the standard of care is a guaranteed recipe for disaster. But definitely ask for a release if the customer refuses to allow you to perform the work in the manner you see fit. But don't think that you can release your way out of everything. You can't. It's not a silver bullet. Now, I don't know the specific facts of your situation. What I've said today is only general information and should not be construed as legal advice. But hopefully this gives you a checklist of some issues that you can discuss with your licensed attorney. If you'd like a free copy of my Refusal of Recommendations and Release of Liability, just send me an email to ed@edcross.com and put refusal in the subject line.